Good morning, my Lord. My Lords, I appear with Mr. Daniel McCourt Fritz, KC, on behalf of THG, the appellants. My own friend Mr. Chasty, King's Counsel, and Mr. George McPherson appear on behalf of the Respondent, Zedra Trust Company. My Lord, can I explain the approach I intend to take and before we get going? I'm going to give a short introduction, but I'm taking it that the introduction has been, skeleton has been read and digested, so I won't be terribly long with that.
Yes, I can tell you we've read the skeleton arguments, including the supplemental one that came from Mr. Chasty yesterday, I think, and we've read the judge's judgment.
So you've read the judge's judgment?
Yes.
And have you read the Court of Appeal's judgment on the last occasion?
In the which?
In this case, the last time we were here?
Yes.
Yes. So, thank you, my Lords. I'm going to deal with the reflections on the purpose of section 994 and 996, and then going to turn to ground 1, then ground 3, followed by ground 2A, then ground 2. And for clarity, we say the correct basis for determining there is a limitation period in this case is our ground 3. And if you're with us, then grounds 2A and 2 don't arise.
I have to remind myself which the grounds are.
So ground 3 is the section 9 of the limitation.
Section 9, right.
Ground 2 is the section 21 of the Limitation Act. Ground 2A is sections 2/5 of the Limitation Act. My learned friend, Mr. McCourt Fritz, will deal with ground 4. We think this is down for 1.5 days, my lord. So, with your lordships, probably got the timing right. I will speak for about 3¼ hours, or Mr. McCourt Fritz and I between us will, till 2:45. My dear friend Mr. Chase will then have until 12 noon tomorrow, and then we'll have an hour to reply tomorrow, finishing at lunchtime. My lords, the appeal is brought with the permission of Lord Justice Arnold in this matter against the judgment and the order of the Vice Chancellor, Mr. Justice Fancourt, when he refused permission on what was complaint 1 and allowed permission on complaint 2 on the basis it wasn't subject to a limitation period.
Yes.
My lord, if one turns to the Court of Appeal judgment in this matter on the last occasion, which is, are your lordships working electronically or on paper?
I'm old-fashioned, I use paper.
My lord, it's a tab 24 of the bundle of authorities. With your lordship's permission, I'm going to use the numbers in the bottom right-hand corner rather than the internal numbers of each of the authorities.
Sorry, I've been looking at it in supplemental bundle. Is there a difference?
No, my lord, the difference because one is a proper law report, the other is
well, no, that's worth doing. So can you give me the authorities tab again?
tab 24, my lord.
Thank you.
Page 827.
Yep.
And in paragraph 4 of the judgment, Lord Justice David Richards, as he then was, recorded the central and by some distance the most important complaint made in the petition is as a result of issues of shares that the Zedra shareholding was reduced from 13.12% to 8.34%. And that was the part which the court struck out. And that was overwhelmingly the highest element in value terms of the petition, estimated at that stage to be worth something around £300 million. And then the order made by the Court of Appeal, you'll find in the supplemental bundle at page, tab 4, page 52. And in paragraph 1 of that order, the Court of Appeal ordered that various parts of the petition be struck out. Paragraphs 40 to 45, which is the dilution parts in their entirety. Paragraphs 2, 3, 4 and 6, the prayer to petition in their entirety. And the phrases and 44, and 44 and 45 in paragraph 5 of the prayer to the petition. If your lordships go to the core bundle, at tab 10,
Have we finished with the report in the case?
For the time being, my lord, yes, I'm going to come back to it in due course. petition starts on page 118, tab 10.
Yeah.
And if one goes on to page 132 in the bundle, so your lordships can see what it was that actually struck out. All of paragraphs 4, there is a section headed diminution percentage shareholding since February 2016. So all of pages 132, 133, and the first half of 134 down to paragraph 45.
Yeah.
And then in the prayer, which is at page 135 of the bundle, all of 2, all of 3, all of 4, all of 6, and then in 5 the words and 44 in the second line, and in the last line 44 and 45. What was left after that was the declaration of information obligation, which is a defined term, is valid and binding on the company and its directors and shareholders. Then a claim for equitable compensation at 5. That at that stage related to co-sale rights, and we'll see that those are no longer pursued. And then claims for the company to pay damages to Zedra in respect of losses caused by the breach of the information obligation. Further alternative, the directors, shareholder directors, pay damages to Zedra in respect of the obligation. And my lords, in Zedra's skeleton argument, paragraphs 10 to 19, there appears to be an attempt to explain away what happened the first time round. I'm not going to address that unless your lordships particularly want me to. So what then happens, my lords? So we're in June 2021, and not until May 2022 do Zedra turn around and provide an amended draft amendment. And one can see in the supplemental bundle, that's tab 7, we have the witness statement of Mr. Charnley in support of the application to amend. And at paragraph 17, having quoted 16 parts of the judgment of the Court of Appeals, that's on page 64, my lords. The petitioner has therefore spent extensive time and effort investigating and analysing the circumstances in which the share issues to find the petition were made, with a view to identifying all respects in which such share issues can be challenged and or were unfairly prejudicial to the petition, to the petitioner. And that led to the Vice-Chancellor to say in his judgment in the core bundle at tab 7 at page 88.
Page
88, my lord. After a substantially adequately explained delay, Zedra solicitors finally sent a copy of the draft Re-Amended Petition to the Respondent solicitors on 23rd May 2022, almost a year after the Court of Appeal decision. It should be noted that wasn't the final version, as we had before the Vice-Chancellor, with 2 further attempts before we got to the one before the Vice-Chancellor.
Without wishing to spoil the sort of jury points, I mean, is there actually any point turns on the history of the delay in production of the amended petition?
Well, only, my lord, that it's because of the delay the matter has become statute barred.
Okay.
So we've set out in our skeleton up to paragraph 10 why we say this is an attempt to reverse engineer a petition, one which ultimately was unsuccessful in respect to complaint 1, and will, we say, ultimately be unsuccessful in respect to complaint 2 if we have to litigate it. Can I turn then, please, to the purposes of sections 994 and 996? The Act is in the bundle of authorities. I'm sure you're all very well acquainted with it, but it's in tab 43, the bundle of authorities.
Do you want us to turn it up?
Not particularly, my lords, just for a moment. But it provides a remedy if the affairs of the company have been conducted in a manner that is unfairly prejudicial to the interests of the members or some part of it. If I can invite you to go back to the judgment of the Court of Appeal in this case on the last occasion, tab 24, to paragraph 7 of that at page 831. Lord Justice David Richards set out at paragraphs 8, 9, 10 and 11 the fundamental principles behind section 994 petitions. Relationships are governed by the terms on which the shareholder has agreed that the affairs of the company should be conducted. Those are agreements in the Articles of Association and the Shareholders Agreement, along with the statutory duties of directors and principles of power of law which limit the power of the majority of members to bind the minority by resolutions in general meeting. The agreements are with the other shareholders and with the company. They are essentially contractual in nature, that is to say they are rights in law as opposed to rights in equity. And as he said at paragraph 10 in relation to the instant company, my lord, as we see in the circumstances of the present case do not call for the application of the equitable considerations discussed by Lord Wilberforce, the relationship between all the parties has at all times been entirely commercial, as evidenced by the detailed and complex provisions, including those the protection of members' interests, contained in the company's articles and in the shareholders' agreement to which Zedra acceded when it became a shareholder. So we are not in a quasi-partnership situation, so Zedra is not entitled to complain of unfairness unless there's been some breach of the terms upon which they agreed with the company and other shareholders that the affairs of the company should be conducted. So what is section 994 doing, my lords? It's providing a remedy for a situation where there's been a breach of the terms upon which it's been agreed the company will be run. So essentially, it's providing a remedy for what is a breach of contract, or if not quite that narrow, for what is a breach of the entitlements that the minority shareholder has at law. It is not in itself creating an entitlement for breach of any equitable obligations. And the fact that the remedy is a discretionary one does not mean that what is essentially being protected is other than the minority shareholder's entitlements at law. Now, section 996 is the provision which says that the court has power to give relief in respect of those matters complained of in respect to the breaches of the agreement. And various examples are given in section 996(2), and we'll look at those in due course. It provides a wide and flexible remedy, as Mr. Justice Voss, then, as he then was, said in the Apex Global and Fancourt case, which is quoted in paragraph 11 of the judgment of Lord Justice David Richards. So accordingly, this is a restorative, in essence, a restorative power, seeking to restore the position to that which it would have been but for the breaches of the agreements. The court is given the power to grant a remedy. Whether or not the court decides to grant a remedy is a matter for its discretion.
It's not just restorative, is it? I mean, it can. It's actually designed to cope with situations where there's actually been unfair prejudice or where there's a threatened unfair prejudice.
My lord, it certainly can arise as it were, in advance. That you can try and get relief to stop something happening in the future, which would cause unfair prejudice, yes. But that essentially, a restorative, that's a clumsy word, is to put it back in the position the parties had agreed the company would be run on, the basis the company would be run on.
Well, it's just to enforce the contract.
Yes, well, yes, yeah.
In fact,
yes.
Whether retrospectively
or prospectively. Certainly. And so, my lord, we say this is very similar to what the court can do in other provisions, such as section 423 of the Insolvency Act, which gives the power to reverse the transactions and restore the position to that which it would have been were it not for the various breaches, transaction undervalued in that case. We're going to look in due course at section 213, 214, 238, 239, and 423 of the Insolvency Act, which are relevant, we say, when it comes to the question of the limitation period.
I mean, there are material differences in the sense that the Insolvency Act, the antecedent transactions group of sections that you're talking about are premised upon the basis that prior to insolvency there's a period during which transactions, the effect of transactions can be reversed because of the effect they've had on creditors.
In 238, in section 238 and 239, yes, my lord. There's no limit in section 423. There's no limit in time before the bankruptcy. As we'll look at the Spread Hill Trust, Hill and Spread Trust.
Yeah, but that's a transaction that the purpose of which is to defeat the interests of creditors.
Yes. So my lord, I say that it's analogous, it's not identical, but it's analogous. But what we do have in those sections is a menu of options. The court is given the power to do whatever it likes. And here's some examples the court might think of doing.
One further difference is that at the time when you enter into a transaction designed to put assets beyond the reach of creditors, you're not actually in breach of anything. It's a perfectly lawful transaction. The court comes along afterwards and says, oh, well, now you can see the effect.
That's right, my lord.
You start up a business thinking it's going to be wildly successful, but just in case you put your house in your wife's name.
My lord, absolutely. I mean, that's we're saying it's analogous, we're not saying it's directly the same. But when we look at, in due course we'll come to that, and we'll look at them, we'll show you how analogous it is. We say it's a very useful analogy here, because there this court has held there are limitation periods, and there's no reason why the same shouldn't apply in a section 994 situation.
You've stressed the point that if section 994 provides a remedy for breach of entitlement at law, but equitable considerations can come into play, as we know from Lord Wilberforce and Lord Hoffman.
In a quasi-partnership type situation, yes, my lord, can do. But equitable considerations doesn't mean that the equitable restraint rather than consideration. So it operates an equitable restraint on the party exercising their strict rights under a contract, under shareholders' agreement or articles of association, where the parties have agreed in an informal way that it should be conducted in some other way.
I wonder whether it's just a question of the interpretation of unfairly prejudicial as a matter of statutory interpretation, which is informed, or can be informed, both by legal and equitable considerations.
Well, so my lord, in a situation like this, it's a legal consideration because we've already, it doesn't, as Richard says, it doesn't arise. The equitable restraints don't arise. In a quasi-partnership, it's a much more informal situation, but it's still not, you're still protecting a right at law by virtue of the equitable restraints. I mean, ultimately, we say it doesn't matter, but the purpose of this is that when one looks at the limitation periods and the application by analogy, we may be into the question of is it a legal right or an equitable remedy for a legal right or an equitable remedy for an equitable right. So that's why I set it out this way.
Yeah.
But just to be clear, I understood entirely why you say that if you take Lord Hoffman's approach in O'Neill and Phillips, which is what everybody goes back to, that you ordinarily can't complain that you've been treated unfairly prejudicially as a shareholder unless there's a breach of the agreement on which you entered into which you entered when you bought a share. And that agreement is to be found in the articles, the statute, the Companies Act, as far as a director's conduct is concerned.
And a shareholders' agreement if there is one.
And a shareholders' agreement if there is one, possibly, yes. There are issues about that, but yes. So I understand entirely why you say primarily this is to be analogized to a claim in contract, a breach of contract. And then you have overlaid on the top of the contract equitable restraint, as the little quote that we've just been looking at, you can't exercise your legal rights in a way which equity would regard as being in contrary to obligations of good faith.
In a quasi-partnership type situation.
Yes, that's right. And they don't exist. I mean, there's quite a long judgment of the Court of Appeal that I was responsible for, which points out why you can't necessarily have equitable restraints in every case. Is this really all aimed at not so much the drawing some analogies with Insolvency Act provisions, which I at the moment find less helpful, but pointing out that when this is said to be a claim for equitable compensation, that's not really what it is.
It's a claim for money, my lord.
Yeah, it's a claim for a remedy pursuant to statute.
Indeed. So 994 gives you if you establish a 994, the court can give a remedy. What remedy is it being asked to give? It's being asked to give money. And that is a claim effectively for damages. Well, it's called equitable compensation.
Yes, I mean, damages is a common law concept.
Yes.
It's a claim for an order that somebody should pay money referable to a loss.
Yes, that's right, Lord, yes.
And you can stick whatever label you like on it, but it's a statutory remedy.
My Lord, yes. So in July, the complaint that's left is July 2016 complaint, and that's set out in the Re-Amended Petition claim, which your Lordships will find in the core bundle, tab 15, in the Re-Amended Petition. And can I take you, so that's at page 178 of the core bundle. And then I take your Lordships to start with the prayer, page 206. See what is left. So, paragraph 1 still keeps the claim for the declaration of information obligation is valid and binding. I'll come back and deal with that briefly in a minute. You will see that paragraphs 7 and 8 have gone. Claims for damages for breach of that obligation have gone. And then in subparagraph 5, you'll see that the paragraphs 27 and 37, 29 and 39 have been struck through. And what we're actually left with is 45D and 45F. So that's what the claim for equitable compensation is for, just that. As to the declaration, the information obligation is valid and binding, that arises out of the shareholders' agreement. And that was all got rid of before the IPO when this happened. So we, in our supplemental submissions on the form of the order, said to the Vice-Chancellor, that should go, because there's nothing left in there. And he said, well, that wasn't part of the application, so we'll deal with that in some other time. So that does remain in the petition, but it serves no purpose at all, because no loss is claimed as a result of it.
So that's an application that is pending.
Well, the Vice-Chancellor, when we both said we wanted permission to appeal, effectively stayed the proceedings until at the outcome of the appeal. So we haven't, and then there's going to be a CMC after the appeal, at which various matters will fall to be decided, depending on what this court decides.
But we're not concerned with that.
You're not concerned with it, but it's safe to say that we say that's all that's, if you strike out or you refuse complaint 2,
Yeah.
we say there's actually nothing left in this petition at all.
But if you, this paragraph, subparagraph 5, is anchored in Lord Justice David Richards' judgment in the Court of Appeal at paragraph 66, isn't it?
Where he says equitable compensation can be paid, yes.
No, he doesn't.
Oh, sorry, I've had short, I said that too shortly, my lord.
Well, no, it's just wrong. He says compensation can be paid. He doesn't say anything about equitable compensation.
Sorry, my lord, your lordship's right. Sorry, yes.
So, sorry, I thought I was making a point in your favour, but anyway.
Sorry, no, your lordship's absolutely right. I think it was already drafted as equitable compensation
Yes,
in a prior petition.
but Lord Justice David Richards correctly sorry, let me put this to you. Sorry. Do you accept that Lord Justice David Richards correctly analyses the way we should look at subparagraph 5 in paragraph 66 of the Court of
Certainly,
Judgment?
Lord, especially if it's in my favour. Yes.
Well, he doesn't.
No,
He doesn't make the mistake which you say is evident in subparagraph 5 of referring to this as equitable compensation.
Your Lordship's absolutely right, and I apologise for my
Sorry,
actions.
sorry, it's just because we've been discussing this very point. Right. But that's the anchor to subparagraph 5.
That's right, my Lord, yes.
Yeah.
That it can exist. So it's cited by my learned friend's escalation argument that this remedy can exist because of what Lord Justice David Richards says in paragraph 66
Yep.
of the judgment. So if one then goes back and see what 45D and 45F say, 45D, your Lordships will find at 204. I just invite your Lordships to read 45D. It says for breaches of the allotment duty and the capitalisation duty. I'll take your Lordships back to see what they are in due course. And you'll see it said the purported variation of the dividend rights was unlawful and or ineffective. And then 45F, my Lords, is the allegation of bad faith. An inference of bad faith. Can I just invite your Lordships again to read paragraph 45F? I'll come back to those in due course, but just ask you to note what is said there at the moment. Then if one goes back to the prayer at subparagraph 5, although it says for an order of directors of the company involved in the breaches of duty pleaded at paragraphs 45D and 45F above, there is no breach of duty pleaded at paragraph 45F at all. It's just an inference of bad faith. So effectively, the claim is for the breaches of duty pleaded at paragraph 45D. Now, the permitted amendment relates solely to the allotment on the 11th of July 2016. And it's not said that any of the directors from whom equitable compensation is sought were the recipients of those shares. There's no personal benefit alleged in respect to any of those directors. Page 191, your Lordships will find paragraph 21L. Your Lordships should have a heading, Zedra's rights as shareholders under the articles in the SHA. 21L. Pleaded on true construction of the articles in light of A, the duties of the directors, set out at paragraph 9 above, and section 630 of the Companies Act 2006, set out paragraph 21K above. The directors of the company were under a duty to act lawfully in good faith for proper purposes and fairly as between different shareholders when exercising the following powers: the power to allot shares to the company, and the power to capitalise profits of the company and appropriate capitalised sums to shareholders pursuant to paragraph 21L above. capitalisation duty. It's not expressly said these were duties owed by the directors to THG, the company, but that's how it's been argued, how it was understood by the Vice-Chancellor, and how we address the matter.
Well, it is expressly said that, isn't it? Because in paragraph 9, it is a reference back to duties owed to the company under the Companies Act.
Yes, so it said, my Lord, it simply says that in light of those duties, these further duties were owed. So I don't think there's any issue between us. It is alleged, these are allegations of duties owed to THG, not duties owed to Zedra.
Yeah, I mean, because the duty to act for proper purposes is expressed in the Companies Act, and so is the duty to act fairly as between different groups of creditors. Groups of shareholders. I can't remember the exact wording.
My Lord, the statutory duties in 172 following, yes.
Yeah.
They're all there. So the use of the 994 petition, therefore, is the procedural device to allow Zedra to complain about these breaches of the duties.
And we see, I think, from 45 G and H, what the alleged loss is that Zedra would have converted the shares. It should have been allotted and they would have sold them.
My Lord, yes. So 1,979 shares would have been what they would have been allotted on a pro rata basis.
So why do you say it's a procedural device? I mean, it is the procedure.
Yes.
By which shareholders
bring claims to vindicate their rights. Yes.
That they have been unfairly treated as a consequence of a breach of duty by a director.
It's not. It is the means by which they can bring.
Yeah.
It is the procedure which allows them to bring the claim. It's not like a Section 212 procedural device under insolvency. It's not a summary proceeding.
Right.
Sorry, it is the mechanism by which they bring a claim.
Yep.
Now, my lords, we noted in footnote 11 to paragraph 14 of our skeleton that what the Vice-Chancellor did was when we basically wanted permission to appeal, he left in 3 of the directors, because 3 of the directors did not become directors until after the 11th of July 2016. You can see that at paragraph 8 on page 180. There's a list of the directors and when they became directors. So on the last occasion, the Court of Appeal required directors 13 and 14 to be removed. But we said directors 10, 11, 12 must come out because none of them were there at the time. And that's something which, now that permission to appeal on complaint 1 has been refused, that must follow. So we're really concerned with directors 1 to 9 in this application. Now, I've taken you to the prayer to show that Zedra do not assert in the pleading or indeed in the skeleton argument, they don't advance the case that anything could be granted by the court other than what they call equitable compensation, so monetary relief. That's all they are claiming. We dealt with paragraphs 17 through to 22 with the judgment of the Vice-Chancellor, but your Lordships have all read that, so I don't intend to take you back through that. And so we then turn to ground 1, that Cherry Hill skip hire is not determinative. And we appreciate, of course, that 2 of your Lordships sat in on that case and agreed with the judgment of Lady Justice Andrews.
I mean, you are certainly asking us to overturn something like 40 years of received wisdom.
I'm not inviting you to overturn 40 years of received wisdom at all, my Lord. I'm inviting you to consider for the first time the question of whether there's a limitation period.
I understand that. I mean, it's surprising to me, at least, that in the over 40 years since this remedy's been on the statute books, nobody's ever actually argued and decided the point.
Oh, well, your Lordship's right, not been argued and decided. It's rather like in the head and spread trustee case, the Act has been in since 1571, but it took until Lady Justice Arnold, I think in 2006, to say there's a limitation period. So this is a mere babe in arms compared to what's now section 423. And my lord, your lordships clearly agreed with the judgment, but that was not argued before your lordships, and therefore, for reasons we'll come on to us, it's no part of the ratio in that case. But even if it is part of the ratio, it's one where, having been no argument on it, and it merely being assumed, this court is not bound to follow it.
I think you're hard pushed to say it wasn't part of the ratio.
Well, may I explain to your lordships? May I have a go?
Yeah.
At that. Certainly, let me have a go and see where we go, my lords. With respect, say it wasn't part of the ratio. If your lordships start with the question of what is the ratio of a case, in a case called R. Youngsam versus Parole Board, 2020 Queen's Bench 387, which is in the bundle of authorities at tab 31, page 971.
Sorry, tab?
31, my lord. This is a decision about prisoners' rights. The facts of it don't matter. What's important is whether it is the observations of Lord Justice Leggett, as he then was, paragraphs 48 onward, which starts at page 4, bottom page 995, my lord. This was described by the Master of the Rolls, Sir Geoffrey Voss, in the recent case of Churchill and Merthyr Tydfil, CPC, 2023 EWCA Civ 1416, as an incisive judgment worth reading in full. And
Sorry, where are you? 48?
48, bottom of 995.
Yeah.
The heading attempts to define ratio.
Yes.
And then he goes through to page 59 on page 999, which is the bit that the Master also says is worth reading in full. Would your lordship like me to read it out, or can I invite your lordship?
You're at paragraph 60 now, are you?
I'd like you to read from 48 to 59.
48 to 59. Yes.
So paragraph 51 is worth emphasising. Therefore, seems to be that when the ratio de sedendo is described as a ruling or reason which is treated as necessary for the decision, this cannot mean logically or causally necessary. Rather, such statement must, I think, be understood more broadly as indicating that the ratio is, or is regarded by the judge as being, part of the best or preferred justification for the conclusion reached. It's necessary in the sense that the justification for that conclusion would be, if not altogether lacking, then at any rate weaker if a different rule were adopted. At 58, his lordship said the starting point is always the rulings and the reasons given in the judgment to justify the court's decision, read in the light of the facts of the case and the issues that arose. In Cherry Hill, as we will expand upon in due course, there were no rulings or reasons given to justify the comment that there's no statutory limitation period applicable to unfair prejudice petitions. It was not part of the best or preferred justification for the conclusion reached, and therefore we say it's not part of the ratio. I'll go into the case in more detail in a moment to make that good.
But it's difficult to see how we could have decided what we did decide if there had been a limitation period.
The point was simply not taken before.
Well, I understand that.
And therefore, I'll come to the analysis of the case in due course to show how you could have decided what you did even if there is a limitation period. But we say, point simply, there wasn't a ruling or reason given to justify that comment, and it was just common ground before your lordships that you should apply what Mr. Justice Fancourt had done in the Edwardian group case. We'll come on to look at that in a moment as well. But the court can only decide on the court normally only decides on the arguments presented. And when the parties all accept a particular state of affairs, that doesn't become part of the ratio of the case. But I'll come on to that if I can.
Maybe not, but we're going to have to look at Kadim to look at that, aren't we?
Yes, you're right. Kadim's a slightly different point, my lord, but yes, I'll come on to that if I may in due course. So one starts by looking, as he says in paragraph 58, but if you can engage, the question of whether or not you can engage in an assessment, as it says in paragraph 5, depends on a wide variety of factors. And if one looks at those, one, the degree of unanimity or consensus among the judges, assuming there was more than one who decided the case, but the three of you agreed. Two, the clarity or otherwise the ruling and of the supporting reasoning. The ruling was clear, but there was no supporting reasoning. Whether or to what extent the point on which the court ruled was in dispute and or the subject of the argument. It wasn't in dispute before your lordships, it wasn't the subject of the argument. Whether or how clearly the court evinced an intention to establish a binding rule. With great respect, you had no intention to establish a binding rule, which is what you accepted was the position. Whether and to what extent prior relevant authorities were considered by the court. There is no citation of authority on the point at all, my lords. Whether the court would or sensibly could have reached the same result if it had not ruled as it did, and we say yes, you could have done. Whether the court's ruling has been applied or approved in later cases. It hasn't actually been applied. It's been
Sorry, I understood where you entirely up till 6, but I thought the point. I mean, we haven't looked at the case yet, but if there had been a limitation period,
well, my lord, so
how could we have reached the same result?
I'm going to come on to that, my lord. So I'm simply saying, I'm giving you the checklist, and I'm going to come into Cherry Hill to explain why.
Okay, all right.
So I'll come into very shortly. I just want to go through these other points, if I may. So whether the court's ruling has been applied or approved in later cases, there is a mention of it in Smith and the RBS and the Supreme Court. We'll come back to that in due course. But it hasn't, it's been applied obviously in this case, but not other than that in terms of the question of limitation. Whether the ruling or its underlying reason has been criticised by commentators, by judges in later cases, no, not yet. Whether the court considered or contemplated the factual situation that has arisen in the current case, no, we weren't contemplating this situation. The level of the court hierarchy of the court which decided the precedent case in comparison with the level of the court deciding the current case.
So when you say no to 9, I mean, the issue in Cherry Hill, as we will look, is should people be allowed to bring claims for unfair prejudice a very long time after the events which gave rise to them?
But only having discovered them, in that case, 2 years before the petition. So when you look at it, you actually, what you decided, I mean, it seems somewhat generous ruling of your lordship's effect to say that it's all a bit of a mess, but if we rework it for you and you pick this bit and that bit, you might be able to go away and replead it and have another go at it. But you weren't actually, what you actually were deciding, we say the ratios in paragraphs 46 to 48 of Cherry Hill, is that where you've got a passive shareholder as opposed to an active one, who assumes the company's being run perfectly well, and then only discovers 2 years before the petition that it's all sorts of things being going wrong, that opens a door to allow the petition to proceed. But I'll come onto it in greater detail. So there's the checklist. Can I take you then to Cherry Hill, which is at page 204, tab 7. Two of your lordships were in the case, so you'll remember it very well. Lord Justice Arnold wasn't, but I'm sure has read the authority. The head note sets out the basic facts. Then there's the held section, which doesn't actually affect what was decided in the case. It's just a summary of what it is. In this head note, there's no reference to being no limitation period. I know friends have produced an All England report where the head note does say there's no limitation. If I go to paragraph 36, page 213. You have the statement, there is no statutory period of limitation applicable to unfair prejudice petitions. It was common ground before us. Where there's been delay in the issue of petition under 904, the correct approach is that which was adopted by Mr. Justice Fancourt in the Edwardian group case. And you there then set out paragraph 571 of his judgment. You don't refer to paragraph 570 of his judgment, which is at tab 13 of the authorities.
Do you want us to turn that up now?
Yes, please, my lord. At page 500, it starts at page 523. So in paragraph 570, he sets out the argument that delay was presented in a number of different ways. Different ways. And page, letter A over the next page. The second way in which the argument was put was that the equitable defence of leaches either applies or should be applied by analogy, and or the provisions of Limitation Act 1980 should be applied by analogy, as they would to a claim for breach of fiduciary duty that does not involve either fraud or claim to recover trust property, i.e. 6-year limitation period. So what he then did was to decide, with these various submissions being made, that actually the way to do it was, as he said in 571. We say, in fact, the way they argued this case wasn't the best approach. They should have been argued under Section 8 and Section 9 of the Limitation Act. Had they done so, you'd have been into a 6 or 12-year limitation period as appropriate, and therefore there wouldn't have been limitation probably wouldn't have been an issue, because if one goes back to 568 to see the findings that he made, where he's considering this, only one of them falls outside the 12-year limitation period under Section 8 of the Limitation Act, which is the initial breach of the fiduciary duty in acquiring for himself shares in the other companies. But that was, of course, a continuing breach, the continuing breach being the duty to disclose that. And that continued to 2008, which is a mere 7 years before the petition was presented. So that could only be barred if there was a 6-year limitation period, but not if it's a 12-year limitation period. The relief being sought and granted in that case was a buyout order, buyout of the shares. So that's an action on a specialty, brought under 994, where the limitation period would be 12 years. So none of the other allegations would have been caught by any limitation period, be it 6 or 12 years. Petition having been issued in November 2015. So we say it's understandable why, with a number of allegations being made out, the vast majority of which could not have fallen foul of limitation, that his lordship, when fashioning relief, just looked as the question of delay. And he didn't have to analyse and did not analyse any limitation arguments at all. So there's no analysis in his case, in his 571, as to why there is or isn't a limitation period. What he did say is there's no statutory time limit for issuing a petition, nor does the equitable doctrine of leeches strictly apply where the relief sought is not equitable relief. They just stated it in 571. Now, therefore, if one goes back to Cherry Hill, I'm sorry to jump around, go back to paragraph 36, page 213 of the authorities bundle. So, was that first sentence part of the ratio? We say no. You can test that by asking whether the outcome of the appeal would have been any different if that sentence were to be deleted from the judgment. The answer, we say, is no, because you weren't addressed on it. It was common ground between the parties as to what approach should be adopted by the court. Alternatively, you pose the Youngstown question. Would the justification for your decision be weaker or lacking if that sentence were deleted? Again, the answer is no, because it was common ground before that the approach adopted by Mr. Justice Fancourt in Edwardian should be applied. So we say where this has happened, the Court of Appeal isn't holding that such a comment is part of the ratio. Indeed, we can see that in due course we're going to Hill and Spread Trustee, we can see that in that case, there had been a previous case called Law Society Southall, where no one addressed the court on limitation and assumed there was no limitation period. And the subsequent Court of Appeal said, well, there's no reason there. This doesn't assist us, doesn't help at all, doesn't bind us in any way. It's of no use at all. Now, so what was argued before your lordship in the Cherry Hill case? If one goes back to paragraph 1 of the judgment, page 206.
Sorry, I missed the last one.
So page 206, my lord, paragraph 1 of the judgment.
Yep.
The issue for your lordships of this court in that case is this appeal concerns the question whether prior to trial the court was wrong to dismiss in its entirety a petition seeking relief under section 994 to 906 of the Companies Act on grounds of long delay or acquiescence by the petitioner in the conduct of which he now complains. There is no reference to limitation there at all, simply delay and acquiescence. The question of whether there was a limitation period was not before this court. One goes to paragraphs 46 to 48 on page 216. That, we say, is the ratio of this case. Where this court drew a distinction between someone who knows he's been excluded and fails to complain about that for many years, and a passive shareholder who knows he's not keeping the company's accounts, etc., does nothing about it but discovers years later that money or corporate opportunities have been diverted from the company for the benefit of its directors, in that case the petitioner, and he'd only discovered those things 2 years prior to issuing the petition. And the 2 years comes from paragraph 32 of the judgment.
But the rule, well, the proposition, I think, which the court adopted was whether it was plain and obvious that even if all the complaints were proved at trial, the judge would refuse to grant him equitable relief because of delay.
Because of delay, my lord, yes. No, nobody argued the point of limitation.
No, I understand that.
So that was the issue. And I take it back, if I can, to paragraph 7 of the judgment, just to see what actually happened. So the history of the case is set out in paragraph 7 onward. There was direction of, an application was made to strike out, as recorded in paragraph 8, on the basis of no reasonable grounds to bring the claim, and the failure to give proper because the grounds relied upon was likely to obstruct the just disposal of the proceedings. However, the witness statement served by the solicitor in support of the application stated the main ground of the application to strike out was the allegation on which Andrew relies is so sound he's allowed so many years to pass that his claim for relief is bound to fail. And then His Honour Judge Hodge directed the hearing of 2 preliminary issues. And the first one is the relevant one here. Whether on the facts pleaded in the petition or any parts of the petition should be dismissed on the grounds of delay and or acquiescence, and if parts should be dismissed, which parts? So that was the preliminary issue which came before His Honour Judge Davis. And he dismissed the petition on grounds of delay and acquiescence. His findings have been recorded at paragraph 12 at the bottom of page 207 over to 208. Then paragraph 13, the grounds of appeal are set out. The appeals against the decision to dismiss the petition in respect of some but not all of the grounds. Realistically, he does not appeal against the judge's decision to dismiss the petition as far as based on complaint he was unfairly excluded from the management of the company, nor does he seek to pursue any complaint regarding unfairly prejudicial conduct that allegedly occurred prior to 2001. However, Ms. Tythcott submitted the judge was wrong in principle to dismiss the petition at early stage to the extent that this precluded Andrew's pursuit of complaints of a course of conduct which was unfairly prejudicial to him as a shareholder in and after 2001. He very fairly accepted that at the end of the trial, the judge might decide the delay in bringing 994 petition justifies refusing Andrew any relief, but contended it was wrong for the judge to have concluded that the outcome was inevitable. So it's a continuing course of conduct case. No issue about limitation periods was raised. Now, paragraph 14, your lordships will see that there was a respondent's notice served.
So just to be clear, when you say it's continuing course of conduct, there were 2 different types of complaint. One is everything that led up to his exclusion, which was obviously a continuing course of conduct designed to oust. The second was after he was out of the company and knew nothing about what was going on, a series of complaints about what had been done, for example, non-payment of dividend, the directors who were left in siphoning money off to fund other activities of their own, the classic type of thing. What wasn't the case was a continuing course of conduct of the same type spanning 2001. So there were 2.
And the exclusion from management didn't get pursued.
That's right, and that, obviously, in a sense, he knew he'd been excluded from management.
That's right. So that's the reason for 46. You draw the distinction between someone who knows they've been excluded and the passive shareholder
Yes.
who doesn't know what's been going on
Yep.
and is entitled to assume the conduct of the company has been run fairly.
Yep.
But though that conduct after he was excluded was a continuing course of conduct, not the same course of conduct, but was a continuing course of conduct. And we'll come on to see what the Law Commission had to say about this hopefully shortly. But in paragraph 14, your Lordships will see that there was a respondent's notice issued in which they sought to uphold the judge's decision on the further alternative ground insofar as the substance for Andrew's claims for damages or extra compensation for breach of fiduciary duty owed by the directors of the company. Any such claims brought by Andrew would have been barred by the rule in Foss and Harbottle. Moreover, even if brought by the company, those claims have been statute barred by limitation. The judge should have dismissed on the basis that for those reasons they could not be pursued under the guise of petition. For reasons that will appear, it's become unnecessary for us to address those arguments. So you didn't have to address the question of...
No, that's because the petition no longer claimed any money.
My lord, yes, absolutely. But you didn't say, well, the respondent's notice plainly can't be right because there's no limitation period. So you didn't address that. So that it was raised, but then wasn't pursued. So your lordships did not have to address that. And had your lordships addressed it, had your lordships felt there was a limitation period which barred that, sorry, there was no limitation period, therefore which barred that respondent's notice, then you could have dealt with it there and then.
Yeah.
You didn't. So we say that's where that is. Now, my lords, you will have received the supplementary skeleton argument from my learned friends, which we received on Monday morning. I think you may have received it yesterday, to rely on the case of Smith and the Royal Bank of Scotland. We say it's to rely upon on a wider basis is hopeless, and I'll address. I don't know if it's convenient to address you on that now or later, but what we initially were told, we were going to rely upon paragraph 58 of the judgment, and your lordship will find.
Oh, you finished with Cherry Hill now, have you?
My lord,
Can we deal with one case at a time?
well, sorry, they rely upon Smith for what it says about Cherry Hill.
Oh, I see. Yes. Well,
So-
yes. Smith says that some kinds of cases, some kinds of claims don't have limitation periods. See, UB Tiger and
Yes,
Cherry Hill. Yeah.
and just as UB Tiger is binding, your lordship has held in the Royal Mail claimants case, in this court, you're bound by UB Tiger while expressing some doubts as to whether it's actually right or not. But,
Yeah. Well, what Lord Legate said in Smith is quite clearly overdone.
my lord, thank you. I'll come back to Smith on the other point if I can later on. So, my lord, yes, then we have. We've finished with Cherry Hill, save that we move into Kadim next. So if it is part of the ratio, which you say it isn't, are you bound to follow it? If you're against us in the question of ratio, are you bound to follow it? And we say, no, you're not, because of the case of Kadim versus Brent, London Borough Council, which is in the bundle of authorities at tab 30, my lords. At page 959. So, my lord, this was a case about housing benefit. There's been a prior decision about it, and the Court of Appeal was deciding whether or not it was bound by the prior Court of Appeal decision on it. A head note held the court was not bound by a proposition of law, which, although part of the ratio dated to an earlier case, had been assumed to be correct by the earlier court and not been the subject of argument below. Subject of argument before consideration by that court. But that exception to a modification of strict rule precedent must be applied only in the most obvious cases, limited with great care, and not normally apply unless the point had not been expressly raised before the court. There could be cases where a point had not been the subject of argument, but scrutiny of the judgment indicated the court had nevertheless considered the point rather than assuming it to be correct. But since the Court of Appeal in the previous case assumed that argument of consideration that Regulation 3 of the Housing Benefit Regulations, providing complete test of residence, it did not constitute binding authority on that point. And, my lords, can I invite you to turn to paragraph 16 of the judgment.
Yes.
This is the judgment of the court handed down by Lord Justice Buxton. It's all three. Bill. I invite you to read paragraph 16.
Yeah.
I'm afraid, my lords, that there's quite a long passage on these three from paragraph 20 really right through to paragraph 38. It breaks down paragraphs 20 to 25, 27 to 32, 33 to 38.
No, I'm speaking for myself. I have read this before. I had to deal with similar points in a case called Bilter and Tradition.
Yeah, and I had a case involving this issue last year, so I likewise am familiar with it.
I'm not. Can you just give me very quickly? I'll skim read as quickly as possible.
Certainly, my lord.
Sorry, that was a Monty Python-esque intervention. Sorry, the paragraph. Which is the particular paragraph you want?
You have to read 20 to 25, 27 to 32, and 33 to 38.
Sorry, 20 to 25 and 33 to 38.
And 27 to 32 as well.
Oh, okay.
I mean, a more striking example in one way is the FHSC Group and Glass, which is the case that refused to follow Chartbrook on rectification, despite the fact that the obiter observations of Lord Hoffman had been deliberately applied in Daventry.
Yes. But it's an example of it, my lord. What we said applies here, in this case. I don't want to talk while Lord Justice Snowden's reading.
Well, I'm skim reading what appears from the head note. So, I mean, your point is, even if to adopt the approach in paragraph 17, what was said in Cherry Hill is ratio within that approach, which, just looking at it quickly, suggests it might well be, as my lord said right at the start of this debate, there is an escape in circumstances where it's been assumed without argument.
My lord, yes.
You get that particularly from paragraph 33
Yeah.
My lord, yes.
from Dean, but you need also to look at paragraph 38.
My lord, yes.
Yeah.
Those are the two paragraphs I need to read out if your lordship had not read them.
Okay, well,
We say, my lord, that you get up paragraph 33 and the conditions in paragraph 38 are met in this case because it was assumed and wasn't the subject of decision. The point wasn't expressly raised before the court and there was no argument. And therefore, my lord, we say, even if there is, that is the ratio, and we say it is now, I appreciate your lordship said it's going to be very difficult for me to persuade you it wasn't part of the ratio, but even if it was part of the ratio, this court is not bound by it.
well, I mean, if the determination of what's ratio is done in accordance with paragraph 16 and 17, particularly 17, at the moment I do struggle to understand if it wasn't ratio, how you avoid. Sorry, it looks as if you apply the test in paragraph 17 of Kedim. What was said in Cherry Hill probably was ratio.
Well, it wasn't, we say it wasn't a necessary step because it didn't arise.
Well,
Your lordship did not apply your mind.
Are you talking about Cherry Hill or are you talking about Kadim?
I'm saying in response to Lord Justice Snowden's comment about applying 17,
Yes.
I say even if you apply 17, it is still not ratio because it is not a necessary step.
Well, yes and no, but it depends on what the test is. But
Yes.
the test laid down in paragraph 16 of Kadim adopts the proposition in Cross and Harris and that's not the way the court approached identifying the ratio in Youngsan, having referred to Kadim, see paragraph 48.
Well, except that Lord Justice Leggett was in the minority on that point.
But it wasn't in the minority, that he was the only one who expressed views on it. So Lord Justice Haddon Cave...
Lord Justice Haddon Cave, for sure, didn't agree.
Well, he said there was no need to consider it. But the Master of the Rolls, only a few months ago in this court, said it's an incisive judgment well worth a read, and applied it in Churchill and Merthyr Tydfil in the case about the automatic stay, or the court's power to stay for ADR, as to whether Halsey and Milton Keynes had actually been part of the ratio or not. Well,
yeah, but then you just go in circles, because that just brings you back to the question of whether paragraph 16 of Kadim is ratio and therefore binding or not.
But Lord, then aren't we into the situation where you've got two inconsistent cases, and the latter one is Lord Justice Leggett, and therefore the court should apply the latter of the two inconsistent cases.
Well, yeah, if there was a clear majority in Youngsan, maybe, but he seems to be in a minority if there's a difference.
So yes, your Lordship is right, but it is what Lord Justice Leggett says in Youngsan an explanation of the Kadim. Because they both start from the same place. They both start from the Cross and Harris precedents book. And they both work from that. And it would...
But the simple point is it was simply assumed.
It's simply assumed. And so we say either not past the ratio or not binding. So we turn then, I have now finished with Cherry Hill, unless there's anything further on that.
And with Youngsan.
And Youngsan. Turn next, if we may, to policy reasons in favour of there being a limitation period. Reliance is placed by Zedra on the Law Commission's two papers, the Shareholders' Remedies of the 24th of October 1997 and the subsequent limitation of actions paper from the 9th of July 2001. And they, my lords, are tabs 51 and 52 of the bundle of authorities. And they rely upon the government's failure to accept the Law Commission's recommendations and bring into force legislation enacting them. Now, we say, and I'll take you to passage in a minute, that some assistance can be garnered from these papers as the policy reasons why there should be a limitation period. But insofar as they started from the premise that there was not already a limitation period, they were, with respect, wrong. So just as the author of the court report said in respect to section 423 there is no limitation period, and the Court of Appeal subsequently said that's wrong, the fact the Law Commission has said that there was no limitation period is of no assistance, especially because they rely upon one authority which doesn't say that. Now, when I was at page 1511 in the page 1511, which is the introduction to the Shareholders' Remedies Law Commission paper. You'll see from paragraph 1.2 the focus of the project on the remedies available to a minority shareholder. That's what that's all about. 1.5 and 1.6 at page 1512, you see the second problem they identified in the consultation paper relates to the efficiency and cost of the remedy, which is most wisely used by minority shareholders to obtain some personal remedy in the event of unsatisfactory conduct to the company's business. Section 459 as it then was. At 1.6, our provisional view is that proceedings under section 459 are costly and cumbersome. Unfair prejudice cases which go to trial often last weeks rather than days, and the cost of litigation can be substantial. There's also a significant cost on the taxpayer. And I'm sure your lordships will all recognise those problems. If one then goes to paragraph 1.13 at page 1517, you have at 1.13 13 to 1.16, the provisional recommendations, which were a new derivative action. Effectively, deal it all by a derivative action. And then at 1.23 on page 1519, you get to the main final recommendations, and they set them out. I'd like your lordship to read those.
I beg your pardon, where are you now?
So, page 1519 at paragraph 1.23.
Thank you.
Yeah.
You'll see some
Recommendation 3 recommended a limitation.
My lord, yes. Part 4 deals with other reforms. The parts 2 and 3 deal with derivative actions. But part 4, your lordship can turn to page 1557. There's a heading, imposition of limitation period on claims under the section. As you'll see, paragraph 4.16, there is currently no limitation period for bringing claims under section 459. And the footnote refers to Peter Gibson in the DR Chemicals Limited case. It's also known as ex parte Harris. And I'll come on to that in a moment. But limitation was not an issue in that case at all. There is no other authority cited for what the Law Commission say. They then deal with...
Just out of it, I've got it, but not with me in court, but I can get it. What's in consultation paper number 142, paragraph 9.3, note 11?
Sorry, I did look it up, and I'm pretty sure it's just a footnote back to DR Chemicals.
Okay.
I did look at the time, but I didn't think it added anything, so I hadn't brought it. Mr. McCourtfitz will check that while we're...
I mean, just to put it properly into context, the consultation paper did say exactly the same thing and asked people about whether there should be a limitation period. And there's no indication that anybody, I appreciate this isn't authority or anything, but it's not as if this is the first sentence that ever popped into collective consciousness making this statement.
No.
I mean, the consultation paper, the whole consultation paper,
proceeded on the basis there wasn't one.
well, it made the statement that there isn't a limitation period. Do you think that it's a good idea? Should there be? And nobody apparently came back to the Law Commission, as far as we can tell, to say, but you're wrong, there is one.
Unfortunately, I was too young in those days to be responding to papers. But I accept no one.
For those of us who weren't too young and did respond, nobody seems to have.
No, certainly that's right.
Yeah. Okay.
But as your lordship says, that's no authority.
No. I'm just making sure that it is clear that was what.
Yeah.
I was just curious about the footnote.
So we start, my lord, and we say the Law Commission started from a false premise. Then they go on to suggest more rigorous case management in paragraph 4.17. They considered provision there should be a limitation period. 4.18 didn't make any provision or recommendation on the length of the limitation period. They did express provisional view on two other matters. And they then deal with those two other matters, which is when it should run and whether the court should have discretion to permit proceedings outside the limitation period to continue. And at 420, they recorded the majority of the response who considered the point agreed provisional view there should be a limitation period on claims in section 559. Two particular points were made by those who disagreed. Firstly, several respondents expressed concerns difficult to define a moment in time when a relevant cause of action accrued. The earliest actual omission may not on its own be sufficient to justify a remedy, whereas a whole series would. Secondly, a number of respondents drew attention to difficulties which arise in respect to concealed wrongdoing. They then address those in paragraph 4.21. Don't think there's any problem the problem is any different from that which may arise in any other situation where a potential claimant does not become aware of matters relevant to his claim until some later date. G, the first one accepts that we did in the consultation paper. It's in the nature of the phrase unfairly prejudicial to include a conglomeration of allegations producing a particular consequence. However, we do not consider that this would give the court any particular difficulty in applying the limitation period. Time will be taken to run from the first of such allegations on which the applicant relies. And then they say at 4.22, indeed it may be said that in the interest of commercial certainty, there's an argument that strict rules should apply in the case of shareholder proceedings and some other types of civil claims. However, we're of the view the general rule related to the length of limitation period and the date from which the period should run should apply. Responses received on this point do not highlight any special factors applying to claims in section 459. Then they refer to the fact the Law Commission was at that stage considering carrying out a separate project of limitation, and therefore they left over the question of the limitation period to that subsequent consultation. So they recommend there should be a limitation period, the length of it should be dealt with by that paper. And that paper is at tab 52. Starts at page 1685. And in 1687, in the executive summary, they set out their proposal, which was to introduce...
Sorry, which page?
Sorry, 1687. Sorry.
1687.
And they recommended a radical new single core limitation period for almost all actions for 3 years from the date of knowledge with a 10-year long stop. And that wasn't limited in any way to section 459 petitions, but it was effectively to be applied to every cause of action. At 1857, they deal with proceedings under the section 459 of Companies Act 1985. And one can see amongst other things at 4.211, Mr. George Bompers QC, as he then was, gets a name check and his comments are cited. And again at 4.211 it says 5 lines down, under current law, such proceedings are not subject to any limitation period, though delay may bar relief. And again, it's the same citation, back to Peter Gibson J in DR Chemicals. And they didn't believe there were any concerns to working out when the limitation period would start in that section 4.211 through to 4.218. Concluded at 218, we recommend applications under section 459 should be subject to the core regime, so 3 years from date of knowledge plus the backstop of 10 years. For what it's worth, my lords, at 1875 onwards, the Law Commission dealt with clawback claims in the corporate insolvency context. 212, 214, 238, 239 and 423. They recommended at paragraph 4.264 that they should all be subject to the core regime with some modifications. Now the single core limitation regime has not been adopted for any causes of action which the Law Commission recommended it should apply to. So no comfort can be taken by Zedra, the respondent, from the non-implementation of the recommendations of the Law Commission. They just haven't been applied. We say that the finding by this court that there is in fact a limitation period applicable to section 994 proceedings will deal with the concerns that the proceedings are costly and cumbersome, taking up very significant amounts of court time, and many would say an excessive amount of the court's resources. It won't be applicable in many cases, but in those very old cases, it will be applicable. And we say this: why should a Section 994 petition, which has been brought on the basis of events or a single event which took place many, many years ago, be allowed to go to trial, and only at the end of the trial, after all the expense of witness statements, disclosure, experts' reports, etc., for the court to have to make a finding on acquiescence and delay, and then decide as a matter of discretion whether relief should be granted.
Yeah, I mean, one of the policies behind the whole idea of a limitation period is you don't have to try the case at all.
Quite a lot. And the cases are, we all know from experience of 994 petitions that these cases are massively long and rake over ground, which is, who didn't give a sugar to a director's cup of tea 25 years ago?
But if it, okay, I mean, I understand the point, the picture you're painting, been there, got that T-shirt. But if it's plain and obvious at a preliminary stage that no court will ever grant the relief sought because of substantial delay, then you just strike out the petition, which is what happened, in fact, in Cherry Hill for a large number of the allegations.
Yes, there's no bar. Sorry, but having a limitation period does not mean you can't do that. You can still strike it out for delay, as we're going to see happen in Woven Rugs, for example. It's only 5 years that struck out for delay. So you can still do that. That, I think, was at the end of the trial, rather than, I can't remember.
Yeah, the only point I was making, I think the way you put your submission, you suggested that the limitation period, as it were, is the cure for the ill that you complain of having to go through a long trial and then at the end saying no relief for something that happened years ago. And I'm just making the point that there is another route.
There is another route in the case where there's been clear delay and acquiescence. But how do you decide that? Sometimes you can decide that. Yeah. Sometimes you can't decide that until the trial.
Correct.
So you end up going through this massive trial. Last week's, all the lawyers get lots of money, court's time's taken, and no relief. For something which could have been, if there'd been a limitation period in, would never have got there.
One possible difficulty is that if there is a limitation period, then the claimant has the right to bring a claim within the limitation period, and you can't strike it out for delay.
There's no rule to that effect, my lord.
Well, isn't it Burkitt and James in all those cases? You don't strike a claim out for delay, want of prosecution, call it what you like, if tomorrow the claimant can start the claim all over again.
My lord, that's shown not to be the case. So the UB Tiger, for example, case, which your lordship know, which is the case which showed no limitation period of specific performance. Nonetheless, the Court of Appeal went on to say you could still strike that out, regardless of the fact.
Well, yes, if there's no limitation period, then they in the UB Tiger, it was all done on the basis of equity. Equity will allow you to strike something out or to refuse an equitable remedy, even within the limitation period.
Indeed, my lord, and that's what would happen here.
If it's an equitable remedy.
But yes, but the court has a discretion. So, Mr. Justice Fancourt in the Edwardian Group case, he said, well, he said there's no statutory time limit. He said there's no case of, it's not actually late cheats.
No.
Because it's not an equitable remedy.
But the point my lord is putting to you is that if we start where you started and saying that this is fundamentally a claim for breach of contract of the agreement between members as to how the affairs of the company should be conducted, if there is a limitation period, on what basis can you strike it out if it's brought within the limitation period? It's essentially a breach of contract.
Because the discretionary relief is one which the court is never going to grant. So it's your other point, the other way of dealing with it. So if, for example, we're coming to
yes, but that's a different. But you can't strike it out. My lord's point was you can't strike it out on the basis of delay.
Not necessarily, not mere delay, but delay and acquiescence you can, because that's what the cases show. There's been delay and acquiescence. You can strike it out.
So just to try and, not sure you could strike it out, because if in a strikeout you're looking at the pleading. I can see that you might say, well, you should have summary judgment on the basis that even if all the facts are proved, there's no real prospect that a court would exercise its discretion in your favour. See that way of putting it.
That would be a strikeout as well, my lord, because you'd be saying We're saying
It
there's no.
would be a reverse summary judgment.
Yes, but it is the same. It comes to the same thing.
Well,
This is actually
it results in the petition being dismissed. That is true, but on a different legal basis from striking out.
But if you can strike someone as an abusive process, and if you're never going to get that relief, then you can strike out as abusive process, as you know, and or most people bring a strikeout and a Part 24 summary judgment together.
Okay, but would it in fact, if it's delay and acquiescence, which is your route to this, is it to reverse summary judgment?
It could be middle, but it could also be a strikeout. Because if you say it's plain on the pleadings, there's been delay and acquiescence in this, then you can strike it out for being an abusive process.
Yeah.
And that's what happens in various authorities. And we'll turn to them in a minute, if we can. But that's now, my lord. So we say, first of all, there's no policy reason for there not being a limitation period. All the policy reasons are for there being a limitation period.
Although the policy reasons that the Law Commission accepted led to a different limitation period than the one that you contend for.
My lord, they led to no limitation period because their proposals were not enacted.
No. They were suggesting that there should be a limitation period for these types of cases, which is different from the one that you contend for. So that the reasons why they said that there's no, in fact, there's every good policy reason why there should be a limitation period were tied to the limitation period that they were recommending.
No, my lord, because they recommended in their first report there should be a limitation period without saying what it should be.
Because they were consulting.
Because they were consulting on it. So they did not say in their first, and then they said it falls in the single core limitation idea.
Which was applicable to everything, with a few exceptions.
Indeed, my lord, yes. But they didn't, in the first paper, they didn't say it should not be, it should only be 3 years from date of knowledge. They didn't make any recommendation on that at all. So can we turn to the cases relied upon my learned friends for saying there's no limitation period? And this is in paragraph 4.2 of their skeleton argument. The first is DR chemical limited, which is at tab 12 of page 369.
Sorry, very irritating. I'm going to ask you for the tab again. Sorry, I was writing.
It's tab 12.
Sorry.
It's known as DR Chemicals, but also as Re-A Company number 0034 of 1986, ex parte Harris. 1989, Butterworth Company law cases 383. And your lordship will see on page 370 that the petition was presented on the 8th of July 1986. One then goes on to 381. Letter C to, and then E to F, he deals with the question of the allotment of 900 shares. Which he says is, he couldn't conceive of a more blatant case of unfairly prejudicial conduct. And the facts there. That's page 383D, page 383 of the bundle at letter D.
So, oh yeah, sorry.
383D.
Letter D, did your lordship see just
The purported allotment appears not to have occurred before
October 1983.
Yeah.
That's your date. So October 1983, petition July 1986. So then 383H to I, Justice Peter Gibson says there was unfairly prejudicial conduct, and then at H deals with the question of late cheese. Mr. Justice Peter Gibson said it did not, the delay wasn't such, almost 3 years to present the petition, to mean that it was barred by lateness. So the word limitation doesn't appear in that case at all. Not discussed, it doesn't appear in the judgment. There couldn't have been any limitation period issues because it was only 3 years, under 3 years, between the complaint which was found and the petition being issued. So there is no authority for the proposition that there's no limitation period applicable to unfair prejudice petitions.
And what was Mr. Harris asking?
It was a buyout.
A buyout?
I think. Yes, it was buyout.
A buyout.
Yes, it's back at page 370, letter G. He asked for purchase of shares, other relief, alternative, just an actual winding up. The next one referred to my learned friends is the case of Grand Actual, which is at tab 17. Which starts at page 640. This was an application to strike out because it disclosed no grounds on which to take any real prospect of success. And at 640, letter H, bottom paragraph through to B on the next page, you can see the basis of the application for strikeout relief. The basis being that the complaint had no prospect of success because it related to something which had been done some 9 years before presentation of the petition, because some of the petitioners took part in the offer and subscribed for the issue complained of.
Sorry, you're reading where?
Sorry, by letter B on page 641, my lord. The last sentence.
Yep.
Page 642, letter A, the last sentence of the first paragraph. By the petitioner sought an order, a buyout order. Page 646 is the passage. Sorry, page 646, at the bottom, letter H, through to 647B is the passage relied upon. And he says, I understand that section 459 is not subject to any period of limitation. No analysis of why that should be the case, and no authorities cited.
Where are you?
Sorry, my lord.
Oh, yes, it's paragraph 20.
Paragraph 20, sorry, my lord. No analysis, no citation of authority, no reasoning.
If you are right, this was a claim for a share buyout.
In this case, in our case.
In Grandcastle.
In Grand Actual.
Grand Actual. And on your case, that would have been subject to a limitation period under section 8.
Of 12 years.
Of 12 years. So why is the judge striking it out if it's brought within the limitation period?
Well, my lord, it's the same power that you have under 459 to say it's an abusive process because you're never going to get the relief you're seeking.
Right.
So it makes good the point we say. You still have that power.
Yeah.
The limitation was not an issue there.
No, that I understand.
Woven rugs at tab 39 is the next case referred to. One three two seven.
Sorry, you'll have to give me a second to get that. Tab again, sorry.
39, my lord.
Got the wrong bundle, I think. Yep.
Decision of Mr. Justice David Richards, as it then was. Your Lordships will note from 1327 this is a judgment after a trial.
Yeah.
Paragraph 13, he sets out the history of the matter, which included an application to the High Court for an order under section 371 of the Commons Act 85, convening a meeting with the direction that one member could constitute a quorum, because there had been one of those cases where one of the members was refusing to turn up. 14, the application was heard by Mr. Anthony Mann, QC, as it then was. And then at paragraph 16, he said, as to future prospects of relations between the judges, the party observed at paragraph 32, that evil day is the day of the commencement of proceeding under section 459. And I can see if the parties do not resolve this agreement shortly, such an application is more or less inevitable. And what happened was, at paragraph 17, towards the bottom of page 1331, about 6 lines up, you see Mr. Sharifi was removed from the board in January 2002, and proceedings were not commenced until over 5 years later. And the petition was presented, in fact, in March 2007. And that was one of the grounds of unfair prejudice. The other matters relied upon all data from 2005. And they were held to be established. So paragraph 17, Mr. Justice David Richards said that he considered it was now too late for the removal of him as a director in 2002, being by itself a ground for relief. Again, there's no question of limitation.
Sorry, where are you? Paragraph 17.
17, my lord.
Oh, too late. Yes, got it.
Sorry, so it succeeded on other grounds from 2005, but not on the 2002 ground. Again, no question of limitation, 5 years. The events complained of within any limitation period that could have been applicable. And Mr. Justice David Richards didn't mention limitation, simply wasn't an issue.
If the limitation period was, as you suggest, longer, could he possibly have made those remarks?
Yes, my lord, because you still have the power to.
Why is it too late?
Well, because there's been delay in acquiescence. That's the argument here. That was the basis. It was too late. There's been delay in acquiescence. He'd sat back and not done.
Well, hang on. Too late is different from delay in acquiescence, isn't it? Too late just means too late.
Well, he does go on to say the Sharaf is acquiesced in the situation.
Yeah, I understand that delay and acquiescence may be a ground for saying you can't get relief, but just the fact it's too late would not be open to him if it was a claim brought within the limitation.
No, but as my Lord Justice Arnold says, not just that basis. It's too late and they acquiesced.
Sorry, we're at cross purposes.
Sorry.
I understand that you might say it's not you brought this thing too late, it's that you delayed but acquiesced, the critical bit being acquiescence, in fact.
I think the way that you want to read it, Mr. Ashworth, is that it is now too late because you have acquiesced.
Yes, absolutely.
Yes. Okay.
So it's not saying it's too late simpliciter, nothing else. It's saying too late because you've acquiesced.
Yeah.
Thank you. Tab 32 is Rahman and Malik.
Tab
32, my lords.
32.
Decision of Judge Roger Kay, QC, sitting as a judge of the High Court in Newcastle. Page 1002.
Yeah.
And your lordships will see that this again was after trial. Paragraph 122, the address delay.
Yes.
Again, my lord, there was no question of limitation because the gap was only 1 of 5 years and 9 months. So limitation is not mentioned at all.
Yeah.
Tab 35 is Re-Southern Counties. Page 1074.
I mean, what this really amounts to is that there is a whole series of decisions of the High Court where it has undoubtedly been assumed that there is no formal limitation period applicable to petition under what's now 994. Then there is Cherry Hill. And then there is the obiter approval of Cherry Hill in Smith. That's the state of the law, isn't it?
Well,
apart from the 2 Law Commission reports.
Apart from the first point you make, where you say it's been assumed there's no limitation.
Yeah.
That doesn't necessarily follow. It just doesn't arise in these cases because there could be no issue.
So you're making the point that when you look at a number of these authorities, a limitation could not have been an issue because it was less than 6 years, and not only could it not have been an issue, it wasn't an issue because not a word is said about it.
My lord, yes.
Although I understand entirely the second the point. I mean, I thought there was at least one case where, Sir Donald Ratty's case, where you say, well, limitation. If it's a 12-year limitation period, it was within the limitation period. If it was a 6-year limitation period, it was clearly outside.
Yes, but that was a share buyout case. So that is a 12-year limitation under Section 8.
Yeah, that's the exception to out of these 4 cases or 5 cases. I think it's 4 we looked at so far, because that it does actually contain a statement about a limitation, whereas the other 3 don't.
My lord, yes. My lord, the same point. Can I just? I'm conscious that I'm running well behind where I should be by now. So can I just give you the other citations of the other cases where the same point arises, where there is no, rather than take you to the passages themselves, unless your lordship wishes me to take to the passages themselves. So in Southern Counties, which is at tab 35, doesn't address the question of limitation. What Mr. Justice Warren was concerned about in that case was a course of conduct over a long period of time. And he was saying you don't necessarily exclude the earlier conduct when you're looking at the later conduct. Allied business and financial...
Sorry, what was the reference there?
Sorry, tab 35, page 1074. And then paragraph 70.
So, sorry, 1074 is just the start of the case.
Yes, the paragraph 70 is where he does this. 1091.
Thank you.
70.
70,
Yeah.
page 1091.
Yes.
Well, then, friends, next rely upon the 2 Allied Business and Financial Consultants Limited cases based at first instance at tab 1 and the Court of Appeal at tab 2. page 4, Fundamental Authorities. The petition was presented, in that case, in November 2006, which you get from paragraph 123. There are 4 types of activity or transactions complained about, and one of them only was the diversion of a business opportunity in 1998, some 8 years before the proceedings were issued. The other 3 complaints were later. The petition actually failed because it was found there was no unfairly prejudicial conduct. Mr. Richard Sheldon, QC, the judge at first instance, dealt with the question of 230 of acquiescence, on page 65. And what he therefore said there was obiter. It's not inconsistent with the limitation period of 12 years, or indeed with no limitation period, because it would have been a section 21(1)(b) case, because it was the misapplication of company property. And again, the same points applied to the Court of Appeal decision. No one argued about limitation again. Reliance is also placed by my learned friends on the BVI Commercial Court decision of Mr. Justice Aggregate Judge Mr. Justice Jack at tab 40. Sumitomo Zedra Trust Inspection Galaxy, page 1369. And the page 1396, paragraph 77, he asked the question, what's the effect of the contractual claims which underlay the 994 petition equivalent being barred by the Limitation Act? And with no disrespect to Mr. Justice Jack, it adds nothing because it merely recites the books, which themselves recite the authority, and he followed what Mr. Justice Fancourt had done in Re-Edwardian. Coming to the conclusion, relief should be refused without delay. The relief claim...
Justice Jack is Adrian Jack, I take it.
It is.
Not Raymond Jack.
Adrian Jack. Paragraph 82, you can see the relief sought was for rescission of the investments, not for monetary relief. So on the look and see basis, under section 8, it would have been a 12-year limitation period. That's a further example of what Mr. Justice David Richards did in Woven Rugs. So we say I'm going to refuse relief because of it being delay in acquiescence. My Lord, in my learned friends' paragraph 4.3 of their skeleton argument, they suggest that wrongdoing has been concealed. Now, if that's right, then the way around that is section 32, the limitation period. But, and it's not a reason for saying no limitation period at all, simply apply section 32. But note, there's nothing in their respondent's notice seeking to uphold the judge's judgment on the basis that section 32 is in play. So we say it's not open to them on this appeal to run that argument. There's nothing pleaded by them which would make out a section 32 a point. And it may be said, I think your lordship...
Oh, wait a minute. I'm just thinking of a sort of normal action rather than the 994. You plead some wrongdoing, defence goes in, limitation, you'd say in your reply, wouldn't you, if you're doing it as sequential pleadings, no, limitation doesn't apply because you concealed X, Y, and Z.
My lord, yes, you could do that. But in a case where you're bringing it after a limitation period has expired, or that the primary limitation period has expired after 6 years, in order to be given permission to amend, to add that complaint, you've got to make out your section 32 point in your pleaded case. Because otherwise you can't make out that it isn't statute barred. Yeah, and as my other friend rightly says, you've got to do that because you've only got to show it's arguably statute barred, not that it is actually statute barred.
Yeah.
So he says something just not there. So my lord, we say that there is the power at the end of the trial to say a delay in acquiescence, but that's not a reason for saying the petitioner should be allowed to go the whole way through to the end of the trial and then that to be the finding at the end. That is just a waste of the resources. So my lord, is there a limitation period applicable? We say yes, and we go to ground 3 of our skeleton argument. That's paragraph 57. I should say, my lord, the fact that there's nothing in the Act, either in the Limitation Act or in the Companies Act, which expressly says there is a limitation period, is a point to nothing.
Well, except Parliament has had a go at amending the Companies Act in 2006. In fact, it did in very substantial terms. Against the background of the Law Commission, and it would seem a lot of other people assuming that there's no limitation period.
Well, with respect, that the 2006, the new Companies Act 2006 didn't alter Companies Act 1985 at all.
Precisely.
Because a lot of the Act was simply, sorry, the Section 459 of the Companies Act at all is transposed and put into 994.
Yes, but sorry. If Parliament re-enacted a statute in 2006, you say, or it had the opportunity, if it had wished to do so, to put in a limitation period, in circumstances where everybody hitherto seems to have assumed that there wasn't one. No, you started this by saying the fact that there's no reference to a limitation period in the Companies Act is neither here nor there.
Yes. Exactly as in the Insolvency Act 1986, which was a reworking of the 1985 Act, which in turn, in this in Section 43, for example, was a reworking of the Law of Property Act 1925. Parliament had another go. They didn't mention limitation period there either. And yet this court has found that to be a limitation period.
Yeah.
No, okay, I understand that, but you're saying it's just nothing. You know, there's no significance to the fact.
I'm saying you can draw nothing from that. The fact is not there, because just as it's not there in the Insolvency Act, it's not there in the Companies Act, and these are not new provisions being brought in. These are reenactments of previous provisions. So your point that, well, as I understand your point to be, is that the Parliament could have, if they thought there was one, put it in, especially given the Law Commission had recommended there should be one. The fact they didn't is neither here nor there, with respect.
Okay.
So we say Section 9.1, the Limitation Act, applies to this case, and the Vice Chancellor was wrong to say it did not. And we say it's of direct application here. His judgment was on the basis that for Section 9.1 to be engaged, the action to recover money must be one that gives an absolute entitlement to be paid, whereas a petition, if it's well founded, merely opens the door to discretionary relief. We, with respect to the Vice Chancellor, say that produces an absolute result. That's an absurd result, because a claim to vindicate an absolute entitlement to recover money under a statute would be subject to 6-year limitation period, but to recover money under a statute subject to the court's discretion wouldn't be subject to any limitation period. So Section 9.1 could never apply to bar a claim to recover equitable compensation under statute. By definition, a claim to equitable compensation engages the court's discretion and therefore could not be characterised as a claim of right. And nor because discretion is a matter of equitable relief, can Section 9.1 apply to bar any other claim to discretionary money.
Mr. Ashworth, I'm sorry to interrupt, but you're starting now to develop your submissions on Section 9, and of course that's your ground of appeal. But both in your skeleton and what you've said already to us this morning already, you've put this in the context of Section 8. And speaking for myself, I do find that helpful, not least because if you're right about Section 8, it explodes what you say is a myth, that there's no statutory limitation period at all. And it reframes the debate as being one about whether it's 12 years or 6.
My Lord, yes.
And my reason for raising this is it not helpful then to start with Section 8? Because as I say, if you're right about that, then it does suggest some light backwards on the other questions.
My Lord, certainly, absolutely. So the reason I'm addressing is because the Vice Chancellor decided Section 9 did not apply to this case. The way we say it works is Section 8 applies generally to unfair prejudice petitions because it's an action on a specialty. But so can I take you to Section 8 and Section 9? Maybe easier. Page, tab 42 in the bundles. Page 1425. So an action upon a specialty, bottom of page 1425, shall not be brought after the expiration of 12 years from the date on which the cause of action accrued. By Section 8.2, subsection 1 shall not affect any action which a shorter period of limitation is prescribed by any other provision of this Act. In Section 9.1, an action to recover any sum recoverable by virtue of any enactment shall not be brought after the expiration of 6 years from the date on which the cause of action accrued. So the way we say this works is the general period for a Section 994 petition is 12 years under Section 8.1, but where what you're actually seeking is monetary relief, compensation, whatever compensation you want to call it, then we say it falls under Section 9.1 because it's money recoverable under an enactment, i.e. Section 994 and 996 of the Companies Act.
It's a little curious in a way that some of the sections of the Limitation Act seem to be framed according to what your cause of action is, contract or whatever, defamation, and other sections seem to be framed according to what remedy you seek.
Well, Lord, yes. The amount of litigation that's been over the Limitation Act 1980 might suggest it's time for it ought to be reworked. But yes, you're absolutely right. So some are remedies, some are cause of action. But that's no reason for you not to apply.
I understand that. It's just
Your Lordship's right.
curious.
I can't give you an explanation as to why it is.
Well, it's grown up piecemeal since 1623.
My Lord, yes. Indeed.
But I think my Lord Justice Arnold's point is, why aren't we logically starting with Section 8 in the analysis?
Well, we are, in that the case is Farmisier, Priory, Garage.
Again, you were going to start with Section 9, I think.
Well, I was starting with His Lordship's judgment below, saying so section
He
issues.
doesn't say anything about Section 8.
No, he doesn't say anything about Section 9 because we argue it's Section 9 because we say it is a Section 9
Yeah.
case. So we didn't develop the arguments beyond the fact it's a Section 9.1 case because we say it's money under an enactment. But the authorities, we say, show that's right. But I'm very happy to start. So can we perhaps go to Farmisier Products Limited?
Going to where?
Farmisier Products
Yeah.
Limited, at tab 15, page 596.
Just to be clear, so I'm following this. Your contention is no 994 petition can be brought more than 12 years after the date on which the event said to constitute unfair prejudice occurred.
cause of action accrued.
Yeah, I'm trying to avoid
Right, so it's,
using that expression because that just begs the question. So you say no 99, there's an absolute bar for any 994 petition, whatever remedy is sought, because of Section 8.
yes.
If the event said to constitute unfair prejudice,
If the only event said to constitute unfair prejudice are more than 12 years before the presentation of the petition,
any 9, doesn't matter what relief you seek, it's out.
yes.
But you say that if you are claiming monetary relief sufficient to fall within Section 9, that claim can't be brought more than 6 years after.
That's right.
Right. So it's possible that you could have a 994 petition which falls foul of different sections depending on what the relief sought is.
Yes.
Yeah.
So, and you may have a petition which is brought between the 6 and 12 years, where if the relief, where you might have be seeking different heads of relief.
So buyout order okay, but
Money, no.
money no.
No. That's right. So Farmisier, which is at tab 15 at page 596, was a wrongful trading act, section 214. And what was being said was the limitation period for it. And Lord Justice Peter Gibson in this court held that it was section 9.1, because you can see at page 596, proceedings brought by the liquidators in section 214 of the 1986 for a declaration that the respondent should make contribution to the asset of the company proceedings to recover any sum recoverable by virtue of any enactment, and therefore governed by section 9.1, notwithstanding the court had a discretion whether to make a declaration at all, and as to the amount of contribution, according to the appropriate limitation period of 6 years from the date when the cause of action accrued, since no other period of limitation was prescribed by Arnold section 214 within section 39 of the 1980 Act. The claim would come within 9.1 even the contribution liability for which the court could declare under 214 could be other than a sum of money. If your lordship goes on to page 603.
Well, I think perhaps we ought first of all to look at page 600, at the top of which Lord Justice Peter Gibson sets out the section he's concerned with. And the relevant parts are, if it appears that this subsection 2 applies, the court on the application of the liquidator may declare that that person is to be liable to make such contribution, if any, to the company's assets as the court thinks proper.
Okay.
And then subsection 2 tells you when
So
the court's got that power. But the remedial power given by section 214 is to declare that that person is to be liable to make such contribution, if any, to the company's assets as the court thinks proper.
My lord, yes. If you
Can I ask you this? If the court were to make such a declaration that the director is liable to contribute, say, £100,000 to the company's assets, does it there and then give a judgment for £100,000, or is it for the liquidator to pursue the director?
no, there and then gives makes an order.
Makes an order.
Pays.
Right.
And under section 215, which we handed up a clip of the Limitation Acts bits together, if
Yeah.
that's more convenient.
So the result of getting an order will be a money judgment.
Not necessarily, my lord, because section 215
Yeah.
says that there are other powers. So where under either section, that's like 2152.
Yes, I see. Yeah.
So you can make a charge, and also under 4, you can effectively alter the change of the pari passu principle.
Yeah, but my lord's question was, there's nothing more the liquidator has to go away and do. I mean, he gets a court order.
Oh, absolutely, my lord, yes.
So
yes.
there is a monetary order in the same way as, you know, after a contract dispute, the order would be to pay damages in the sum of X.
Yes.
This is to make contribution to the assets in the sum of X. That is regarded as an order to pay that amount of money to the liquidator and can be enforced as such.
Yes. So the only point I was making is it doesn't necessarily have to be that order. The order could be.
No, absolutely.
So it's one of the available remedies.
Well, the other bits are the court can make further determinations about security or priority in relation.
You can order the contribution to be by way of a charge, as opposed to by way of a money judgment.
Yeah.
So money is the primary relief.
Well, you charge the payment of the monetary sum.
That's right.
On some asset.
But then you wouldn't necessarily get an order there and then for a judgment for Mr. Ashworth must pay £100,000. It would be Mr. Ashworth's property will be charged with £100,000 for the payment in due course. So the answer to Lord Justice Lewison's question was yes, you will normally end up with a money judgment. So your Lordship was on page 600, and you see relevantly there, sections 8 and 9 are set out as well.
Yeah.
So they were considering those. At 603, the letter I. He rejected the. He said the judge's right to reject the liquidator's contention the 1980 Act did not apply. The words in the course of the winding up of the company make clear the court's jurisdiction to make an order under section limited to the period while the company is being wound up, given no more significance than that. And then at 604D to 605A, he asks this: if the 1980 Act does apply section 214, which of the only two provisions suggested applicable, 8.1 and 9.1, apply? And then he then says, I can invite you to read through to page 605, letter D. At 606, letter A, he includes 214 and 213 after recovery for the sum of money. Then asks the question at 606B, does the fact the court has discretion whether to make a direct declaration at all even appears to court section 2142 applies? That's the amount of the contribution, if any, cause a claim made not to be an action to recover the sum of money by virtue of any enactment. I do not think so. If one asks by virtue of what is the sum of £1.25 million recoverable, the answer would surely be by virtue of section 214. Of course, only capable of being recovered if the court chooses to make the declaration after the statutory conditions are shown to be satisfied, but I have no difficulty in holding section 9 of the 1980 Act applies to this case. And we say, my lords, that is quite completely analogous to section 994. What is the money recoverable under? Under 994, it makes no difference. The court has a discretion as to whether or not to make it.
But the difference is that his analysis, or a difference may be, that his analysis is that the wording of section 214, i.e. the word contribution, to make such contributions to the assets, has always been understood to connote a liability to pay money. I mean, those words don't appear in section 994. 994 is much more open-ended.
My lord, as is, and about to see 238 and 423.
Okay.
Well, your better point, I think, Mr. Ashworth, is that Lord Justice Peter Gibson also accepted the alternative argument that when the statutory provision relied on for the recovery of a sum enables the court to make an order either to give monetary relief or relief in some non-monetary form, one should look to what was actually being claimed.
Well, that was the next passage I was going to take your lordship to. Yes, sir. So he does at 606E to G. He says, effectively, you look and see. So what is the actual? So even if you could have any remedy, what do you actually...
That's the approach Mr. Randall took.
It is, in Priory Garage Walthamstow, which is where I was going to go next, your lordship's agreement, tab 29. Page 939. And you'll see at page 940, what was being considered was what is the limitation period to sections 238 to 241. And you'll see he held that case set aside transactions under 238 to 241 and genuine actions as a specialty. Oh, it's tab 29, page 3940. So generally actions are a specialty within the meaning of the Limitation Act, section 8.1, and subject to 12-year limitation period. However, where in certain applications under section 238, 241, the substance of the claim is not to set aside a transaction, but to recover a sum recoverable by virtue of those sections. Such application will be governed by the Limitation Act 1980, section 9.1, and subject to a 6-year limitation period accordingly. He held in that particular case about that it was a 12-year limitation period, and then per curiam, where there is doubt as to whether a claim is subject to a 12-year or a 6-year limitation period, the court should look at the substance or essential nature of the relief truly sought. Given the possibility that a 6-year period might be applicable in any given risk, those who allow that period to pass before issuing proceedings do so at their own risk. Page 943, he sets out the relevant parts of section 2383 and 2393, and it also says section 2411, which is the extent of orders. And this is a wide power, one of which, D, does require, is we can require any person to pay in respect to benefits received by him from the company, such as the office holders the court may direct. But this is, follows, sorry, 994, 996 follow the same scheme. You have the power to do it. Here's a menu, but it doesn't limit what you can do. You have the widest possible power. He goes, sorry, 944, he sets out section 8 and section 9. 945, he records that F, he records it was common ground between the parties that specialty includes an Act of Parliament. That prima facie, a statutory cause of action by insolvency in 1986 will be a specialty within the meanings of section 8 and 9 of the Limitation Act. He refers at the bottom of 945 to the West Riding County Council case. Which was under section 221D of the 1939 Limitation Act, which imposes a 6-year period. C, he recalls, or he's quoting from what Lord Goddard, Chief Justice, said at page 946C. I have no doubt there are matters which may not involve the payment of money. It may be that some functions be transferred without having to make financial provision with regard to them. It's quite obvious to me from the whole of the section, including the following subsection of statute, clearly is contemplated in most cases at any rate, there will be payments of money. And then at the bottom, quoting again letter H, he talks about looking at the realities of the transaction looked at, documents which have been referred and considered. It's simply an action to recover a sum of money by virtue of the provisions of section 151 of the Local Government Act, and therefore he held it statute barred. And he then, at the top of page 947, refers to the look and see approach. Where you look to see what the result is.
In the interest of time, Mr. Ashworth, might it be better if we simply concentrate on Mr. Randall's summary of principle, beginning at the bottom of 955 and going on in the numbered paragraphs?
My Lord, yes, I was going to get that.
957.
Sorry, my Lord, that's 955H.
Otherwise we will get very far behind the time.
I apologise for that. So he sets out the principles in the numbered paragraphs 1 to 5. And his conclusion was that section 8, unless it's a claim for money, in which case it's section 9.1, and he said you adopt this look and see approach if it's not clear what's being sought. If one applies that to the claim made in this section 994 petition, one starts the petition that the section 994 is an action on specialty under section 8 of the Limitation Act, subject to 12-year limitation period, but in this case it's clear they want money. And therefore we say it's section 9 and 6-year limitation period. And that's the only substantive relief. So you don't need even to adopt the look and see approach. It's quite clear that is the only substantive relief. But if you were to adopt the look and see approach, you come to the same conclusion. At 21, tab 21, sorry, we have the Court of Appeal's decision, the Hill and Zedra Trust Company, that's Re-Amended Petition, page 731.
This case a little bit difficult to follow on limitation because the judges seem to have come to different conclusions.
Well,
Lady Justice Arden seems to hedge her bets, and Sir Martin Norse and Lord Justice Waller don't seem to agree with that.
They don't hedge their bets on it being a section 8 or section 9.
No, they don't.
But they don't actually come down to which it is, because it didn't matter in that case. But so, my Lord, one of the issues in the case was, what is the limitation period for section 423 claims? And they held it was subject to the Limitation Act, but it was either 12 years under section 8 or 6 years under section 9. Well, I can see at page 734 what was being sought there was that a declaration that settlement, legal charges and assignments for all transactions under value and should be set aside. They just gave the main judgment, most of which isn't relevant for our purposes, but at paragraph 100 on page 755, she turned to address the issues of law, which she goes into in paragraph 101. Now the issues there were...
So the claim is to set aside settlements, and the order that was made was to set them aside and make an order for repayment of money.
Yes, and there was a respondent's notice which then sought a global order for payment of money.
So, is this right? The actual claim itself didn't actually say repay the money, but that's implicit in setting aside, is it? I'm just wondering about looking and seeing.
Yeah, yes, I think that's...
If you're looking and seeing is, you say the claim, is this right, the claim said set aside a settlement on the basis of transaction defrauding creditors. It doesn't say anything about the consequences of that. But the order that was made was set aside and repay money, is that right?
Set aside and be an indemnity and repay £162,000 plus interest. Now, if your lordship sees the bottom of 734, there's a respondent's notice by the trustee in bankruptcy, which sort of money judgment to put the revenue in the position it would have been in if Mr. Nikovsky had himself sold both the field and the bottom field, the sum of 2 million, and an order setting aside the later charges. So that's what the claim is about, what the respondent's notice was about.
And am I right in understanding the respondent's notice wasn't decided because that was going to be left over for further argument, and I assume that there never was any further argument?
I think it certainly wasn't decided, my lord. I don't know whether there was any further argument, but there's no record of it here. It certainly was left over. That was part of the reason why Lady Justice Arden didn't plump for 12 or 9, but for 12 years or 6 years.
So just going back to, I'm sorry to be slow about this, page 734, letter C to D. So Judge Weeks declares that the various transactions were within section 423. We know from the facts that there had been some compromise with the revenue about capital gains tax. So the settlement trustees now have to indemnify bankrupt estate against any claim by the revenue to set aside the compromise, a claim which hasn't yet been made.
Yes.
And he sets aside legal charges and requires the settlement trustees to repay a sum of money.
Yes. So it's a mishmash, as it were, of relief.
Yeah.
And as I note the time, do you wish me to deal with this case?
Yes, we'll deal with this at 2 o'clock. Now, how are we doing for time?
Extraordinarily
A bit behind schedule, aren't we?
Sorry?
Are we a bit behind schedule?
A long way behind schedule, I'm afraid, my lord. Yes, I haven't. I'm only on. Ground 3 will not be. I've got to deal with the suggestion that Smith in the skeleton the other day as well, and then I've got to get on to ground 3 and 2.
All right, well, I think we need to pick up the pace.
I'll go as fast as I can, Mike.
2 o'clock.
All rise.